All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court now sitting.
Thank you. Please be seated. Good morning and welcome to the Kansas Supreme Court. And if it's not obvious, I'm not Chief Justice Marla Lukert. Early this morning, she did contact me and inform me she was bit by the flu bug last night and will not be physically present for today's docket and arguments. However, she is joining us via the live stream, and she will be participating in all other aspects of our consideration of the cases on today's docket. And Chief, I hope you're feeling better soon. For those of you unfamiliar with the court processes, I would like to explain that all justices are familiar with the facts of the case and the parties' arguments, having read the briefs, authorities relied on in those arguments, reviewed the district court record, and otherwise prepared for today's cases. We now look forward to the parties' oral arguments and our exchange with the attorneys, and I will ask Mr. D.G, Clerk of the Kansas Appellate Courts, to please call the 9 a.m. docket.
First case on the 9 a.m. docket for Friday, March 29th, 2024 is appeal number 125724 in the interest of D.G. Jr., U.G., C.A. and D.G., minor children, Johnson County, briefs both sides.
May it please the court, Richard Klein on behalf of the appellant, who's the father, and I am present and ready for argument.
May it please the court, plaintiff appellee by Assistant District Attorney Kendall Kaut, present and ready for argument.
Second case, appeal number 125241, State of Kansas versus Francisco Alejandro Mendez, Shawnee County, briefs both sides.
May it please the court, I'm James Latta of the Appellate Defender's Office. I'm representing Francisco Mendez. I'm ready for argument, and may it please request 3 minutes for rebuttal.
3
Thank
minutes
you.
will be granted.
Thank you.
Good morning. May it please the court. The state appears by Deputy District Attorney Jody Litvin, present and ready for argument.
Thank you, counsel.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. I will now call the case number 125724 in the interest of D.G. Jr., U.G., C.A. and D.G. minor children. Counsel, please come forward. Thank you. You may proceed.
May it please the court, Richard Klein on behalf of the appellant, who's the father in this case. May I have 5 minutes for rebuttal?
Yes,
please?
5 minutes will be reserved. Thank you.
Thank you, Your Honor. The Court of Appeals has routinely said that a court may terminate parental rights of a parent who are irredeemably unfit, and that even the below average or poor parent should not have parental rights terminated. This case tests those limits. This is a case where regrettably the mother was unfit. The district court found that. The Court of Appeals affirmed the district court, and this court did not accept the mother's petition for review. The father in this case is not unfit. I think he could only be described as a good father. He had a job the entire time of this case. He worked for and still works for the U.S. Postal Office. He bought a home during the case. He always had transportation. He had fantastic visits with his children. And unfortunately, he was married to a mother who used drugs and was a habitual liar. And the question then comes, what do you do with a case like that? Where the father continuously does the right thing over and over again, and the mother doesn't. And I think the answer is, and what the district court probably should have done, is figure out a safety plan with the father and or give the father the opportunity to separate from the mother. If the district court found that the mother was unfit, which it did. And I think that is the crux of the argument for the father.
Counsel, can you, I want to try to get really specific for my own understanding. From your perspective, can you list out the factual findings that the district court made in support of its finding of unfitness of the father?
Yes, Your Honor. So the majority of the findings were that father was tied to mother. That was the bulk of it. Now, in doing that, the court found him unfit for failure to carry out a reintegration plan. In essence, because they had a joint reintegration plan, and nobody would argue that the mother, nobody would rationally argue that the mother completed her reintegration plan, primarily because of her drug use. But I think it would be difficult to say that the father did not complete his reintegration plan because of all the positive things that he did throughout the case. The district court also found him unfit for failure to change his circumstances. I would argue that he significantly changed his circumstances. When the case started, he and the mother were living in an extended stay hotel. And they had one child who had been in the hospital, and the case started primarily because they didn't take that child back to routine visits after he was born. But again, as the case went on, he kept his job. He bought a home, so they moved into stable housing. He always had transportation. He took care of the kids routinely during visits. There were zero problems there. He never had a drug problem. He didn't need to be tested. He didn't have a drug problem. He worked for the postal office, for the postal service. And so I would say he clearly changed his circumstances. The one circumstance he didn't change, potentially that could have been changed, was he didn't leave the mother.
He stayed married.
He stayed married. And
From your
don't see a ton of these cases. And I can go back, if you allow me to, I had a case 10 years ago with a mother who was very young, and she was, without going into huge details on her background, she was financially and emotionally tied to her husband, and they had 4 children together. And she could not get herself to decide before having a trial that this was somebody I should leave. And when she saw, after a 4-day trial, when she saw all the facts, and she had detectives who were on the stand and social workers who were on the stand, and she saw all that information, she understood, well, this is.
Is it leave, or is it the striking the balance between kind of enabling the mother's behavior, lying on her behalf, kind of covering up the mother's behavior at the expense of the children? It seems like that was the focus of the the challenge here for the district court. And is that an appropriate thing to weigh, or how do we look at that? Because that seems to be the factor. It wasn't necessarily leaving the marriage. It's trying to strike a balance between those two considerations of supporting the mother at the expense of the children, or the children at the expense of the mother.
I would argue there was no evidence to show that the father knew the mother was using drugs, or that the father knew the mother falsified documents numerous times. It was just not, he
Well,
did
that's
not
not, I
know
mean,
that.
there's specific findings of fact in the court's order saying that that's not true. I mean, if we just focus on, there were four, she relied on four statutory factors. And if we just, skip to the failure to carry out a reasonable court-approved plan, she said, number one, as of the date of the trial, the kids can't go home to dad. There's no, even without mom, there's no information to show, who would take care of the kids. The dad works 12 hours a day. Because, the whole thing was that mom was the primary caretaker of the dad. Dad never communicated with KVC during the course. Always relied on mom to do that. Mom consistently tested positive and falsified the drug tests. And dad, there was evidence that dad supported mother in her testimony that the positive meth test results were because she was taking legal drugs. And here's a quote from the district court: "Father was not engaged enough to know that mom's substance abuse was a significant issue in the kids not coming home. This evidence proves much of the information mom gave KVC as proof completing the task plans was false. The only reasonable conclusion the court can make from the evidence related to the falsified document on behalf of father," she submitted that document on behalf of father, "is that he is aware of mother's actions and behaviors and has done nothing to correct the false information," because it said that he went to parenting class and he didn't, "or he is so unengaged that he makes no effort to ensure the documentation and information is accurate and truthful. Father has acquiesced to mother's behaviors and actions over the last 40 months, chosen to let mother handle everything." These are all quotes from the district court, "with KVC, including providing proof that planned tasks are completed. And father chose not to testify at the TPR hearing." Why didn't he testify?
That's a lot of questions, Your Honor. So
No, all I'm saying
I'll
is.
see if I can
all-
break down.
Okay, all I'm saying is that you said that there was no evidence, but, and I didn't even, there's more here. Okay, so.
I think I would argue those are conclusions. Those aren't facts, and that it is a fact that father did not communicate very much with KVC.
Very much.
But-
When did he communicate at
But
all?
he obviously communicated with them. Mother was in jail for over 250 days during the case. He continued to do visits with the children. He did visits every week with the children at a minimum while mother was in jail.
What was his plan to
obviously he had-
what was his plan to take care of the children when mother was in jail if the children came home? When he worked 12 hours a day?
You can put them in daycare and you can put them in.
Was there
other-
any evidence from him of what he was going to do?
I-
We can speculate now, but that's what she said. There's just, father's essentially in the same place he was when the case was filed in 2019. What was he going to do with the kids?
He was going to do what any other parent who works 12 hours, single parent who works 12 hours a day does. There are literally hundreds of thousands of them in this state who are working that out and figuring it out. And
Right, they had 40 months to figure that out. 40 months those kids were in care. And on the day of termination, he didn't testify, "This is what I'm going to do with the kids when mom's in jail." What they relied on was mom was going to take care of the kids and I'm going to go work 60 hours a week to support.
I'm not sure that was the plan. You're right. He did not testify to give the court a plan, but I don't think that when the children are not home or the children are not about to be placed home, a typical parent doesn't have a solid plan for what that's going to look like.
Which goes to the fact that these kids were in care for 40 months and the younger kids their entire life, okay? And so how long do we give this father to get a plan together? So is what you're actually saying is that your dad should have gotten more time?
Yes.
He should have gotten another year? That he
didn't
should have gotten more, what should have happened here?
I didn't say a year. I don't know what the time frame exactly would look like.
So on that more time question, it kind of folds into what I'm interested in, which is your argument that there's some obligation on the state to provide an opportunity for a parent in this circumstance to have a reintegration plan that follows the termination of one of the parents' rights? In other words, as I hear your argument, I'm trying to consider the best version of your argument. It is the whole reintegration plan depended on the mom's rights not being terminated. So how can you use my failure, dad's failure against me when you terminated mom's rights? I mean, is that a fair approximation of the sort of catch-22 you're describing?
In part, it's a circular argument. That I think that parents come to a realization that they're gonna have to choose between a husband or wife and their children at different times in a child in need of care case,
Well,
particularly if it's pushing towards termination.
it seems to me the obvious answer to why didn't dad have a plan is because dad didn't know mom's rights were going to get terminated.
I think that's probably true.
But if that's true, what should happen? What's the state's obligation? Is there some sort of obligation on the state to go one at a time?
I think if need be, yes. As a start point, there are not very many cases where just one parent's rights are terminated. Typically, a district court doesn't do that. Even if they're separated and one parent gets their act together and gets a child back home, most district courts won't terminate the other parent's parental rights because you want that parent on the hook for child support, if for no other reason. And then you assume, I think district courts assume that parent will take care of the children and protect the children if need be from the unfit parent.
Let me ask you a question. In the original sink petition on the first 3 kids kind of, was, well, maybe the first 2, when was UG? Okay, so the first sink petition was filed on April 30th, 2019. And then D.I.G. was born on October 28th, 2020. So that was a year and a half later. On about 4 months later, on January 22nd, 2021, that's when the motion to terminate rights was filed. And then the hearing was not held for another 18 months after that. So how could dad not have known that mom's rights weren't going to be terminated? I mean, that's a long time, 18 months to know, look, there's an issue here.
It was 18 months because the family did better, did worse, did better. And I think the father's view was that by the time they moved to Missouri and bought a house, they were doing better. And the district court obviously did not agree with that.
Well, because then when they moved to Missouri, first of all, I mean, she had another baby.
Yes.
They moved to Missouri, so the baby was born in Missouri and then went into Missouri. They don't call it sink, but went into Missouri care. And then that's when all the stuff surfaced about fraud.
Yes. Missouri and
So what
Missouri,
went better during that time?
they were more stable. They had a home, they had an appropriate home.
Did she go to jail during that time?
No,
Was she using drugs during that time? Isn't that when she submitted false drug uh, drug test results during that time?
and and I'll say again, there's no evidence that shows the father knew she was doing that. The first time the father understood that she was using drugs was in couples therapy after they'd moved to Missouri and they had Missouri's version of a child in need of care case.
You're saying that dad, even though she went to jail for drugs, dad didn't know she was using drugs?
She went to jail for theft.
So the record doesn't contain any evidence that dad knew she was using drugs?
It is not.
Weren't the kids drug exposed when they were born?
One of them was, yes,
But he didn't know that.
I understand it.
Okay.
Problem I'm having, shed a light on that, is that I'm going back to the beginning. This person is a father, new father. He's got a constitutional right to be a parent. And the state has no right at that point to interfere. I'm a parent. I don't have to tell you what I'm going to do to take care of my children. I don't have to tell you what childcare arrangements I'm making. I don't have to tell you where I live. I've got a right to live where I want and do what I want and parent the way I want under the Constitution. So the problem I have here in this case is the dearth of information about the father. What significance are the omissions of information in this case, such as got a home, he works, he's got a job, great. He's got a home, great. That home is in Missouri, whereas Kansas children who are subject to court order cannot go. And he completes visitation successfully, but he has no responsibility to make sure that they are cared for other than during his time of supervised visit. So what significance do the omissions of information? He chased off the healthcare personnel after his child was born with the lung problem, and they came to help. They had a plan to come and help, and he ran them off. We don't need you. We're doing just fine. Those kinds of things that you can look at. This is a long question, I'm sorry, but those things you can look at two ways. One way, I don't have to tell you anything. I've got a right to do what I want. And the other way is that you have to recognize there are problems here with regard to your children. And at what point do we say, look, you don't have to tell me anything, but I'm looking at your children and the effect on the children. And at what point does the effect on the children override you as the father's constitutional right to say, I don't have to tell you anything?
I'll answer that two ways because I think it's brings up two separate questions. The first one is cooperation during a child in need of care case. We all should know, you have to cooperate during a child in need of care case with social workers, with the guardian ad litem, with the court. And you have to give those entities information to make them comfortable to close out a child in need of care case, or when children are put into custody, into DCF custody, to reintegrate those children back into the home. That's the first part of my answer. The second part is, I don't think you can look at a record and make assumptions about a father for lack of information. I think it's almost burden shifting. The state has the burden to prove that a parent is unfit. That's the state's requirement by clear and convincing evidence. And I don't think you can ever look at a record and say, I don't know this, this, or this, and make an assumption that that wasn't, as an example, a plan. I don't see that there's a plan. Well, I don't think you can assume that there was a bad plan or no plan when there's just not a plan. It's the state's burden to prove that a parent is unfit.
So the state has to get a warrant to go inside the house and watch them inside the house?
No, and I don't think, there's no evidence that shows the father didn't cooperate with KVC. There's evidence that says the father didn't communicate a lot with KVC and left that to the mother often. But I think that's the case in almost all cases, that one parent gives a lot of information, but it doesn't mean the other parent isn't cooperating or working. He was great during visits, was engaged with KVC during those periods of time when he did supervised visits, and he moved a long ways from supervised visits. The family got to the point where they did at least one overnight visit. So he was doing the things he was supposed to do in the case. He just didn't always, he didn't pick up the phone and call the KVC case manager.
Well, he hung up on him, didn't he?
I don't know. I don't think he ever hung up on
Told him to go
anybody.
away.
In the
Don't
very,
bother us.
in the very beginning of the case, when the case started, he did tell DCF and the hospital that they didn't need those services that the hospital thought were required for their newborn son. Yes. But that's years and years ago.
Any other questions, colleagues? Would you like to finish up your argument?
I don't think I have anything to add until rebuttal.
Okay, thank you.
Thank you, Your Honor.
Cap.
May it please the court, plaintiff appellee by Assistant District Attorney Kendall Kaut. I think probably the easiest place to start here is in the closing argument that Mr. Klein made at the trial hearing at the district court level. On page 151 of the transcript, he said, "Dad's situation is tied to the mom's situation. We acknowledge that, and we always have." And Mr. Klein goes on to say, "And you know, dad's success depends on mom's success." Now, I certainly don't fault at the appellate level advancing a little bit different argument, but I think that argument in closing was undoubtedly true. In fact, the testimony is replete with witnesses saying the way this parenting arrangement was set up is that the father was going to work 5 or 6 12-hour days.
Isn't it crucial that that argument is made prior to mom's rights being terminated? In other words, the termination of mom's rights changes everything, doesn't it?
Justice Deagle, I do think that there is a change in what happens, but I think it leads to a few issues. Number one is it's pretty obvious mom's rights will be terminated based on what's happening in the case.
But you can't assume that. I mean, from the father's, and we shouldn't assume that, because the law, the presumption of the law is that the state has the burden. What I'm trying to describe is what I said earlier as a kind of a catch-22. And let's take it out of this case for the minute. Let's just say we have a pristine father. You imagine whatever that means, with a mom with lots of problems, or it could be vice versa. You're trying to defend the case, avoid termination of either parent's rights. And so you're lockstep. And then one of the parent's rights is terminated. Should that just necessarily spill over into the termination of the second parent's rights, or should they have some opportunity post termination of one parent's rights to reintegrate?
So Justice Deagle, I think good question requires a little bit longer of an answer. I think it would depend on the situation. So given that 38-2269 lists the full factors we know, B8 includes that a parent needs to change their circumstances in certain instances for the best needs of the children. They're in a catch-22 themselves in this situation. Either mother's rights are not terminated, in which case it would be two parents that are problematic staying together, so you'd want to terminate their rights, Or once mother's rights are terminated, it's pretty clear there's nothing in the record. And because 223869B8 requires a change in parent circumstances, or at least allows that as a factor, the fact that father was going to continue to live with mother, have her in the house, and had no evidence of a change in circumstances is why it was
You didn't have an
dangerous.
opportunity to do that. What I'm saying is that the termination of mom's rights is the change in circumstance.
Well, Justice Stiegel, I think that leads to a question about how does the court view this? Obviously, this is a little bit new of a hypothetical, but my view on that hypothetical would be sort of in line with Justice Stanwich's arguments that over 40 months, he had a possibility to say, look, if this is what's happening, I'm willing to raise the kids, or this is what I would do, or I'd work
So it's
fewer
kind of
hours.
like put the burden on one parent to see into the future and understand that, look, I better make contingency plans, kind of a thing.
Well, Justice Stiegel, I think it's not requirement for contingency plans. I think it's over the 40 months that he's married to mother, has children with mother. He has to take some affirmative steps to figure out, is she lying about the tests? What's happening to the children? Why is her probation getting revoked on some of these instances? Why are we now having all these hearings? What's this discovery evidence that's come upon us? So I think that might be a reason the court shouldn't head down that pathway, because it'd be very difficult for district courts, and why prior case law from appellate courts in Kansas would just say, we can look at past behavior to predict future behavior. So close off that door, because as you've mentioned, it gets quite messy. And over 40 months, we have a record, at least in this case, the court also wants to punt on that question for the future of saying father is unfit for other reasons. I think those other reasons would certainly include the faking of the parent test results. Now, the district court goes through two lines of thought on this. The first would be father is part of this process because he's supposed to be in these parenting classes, so he must have faked them too. Or the second one, again, is at what level do omissions become sins of commission? And in this case, there are so many, even in the light most favorable to father, sins of omission, they become sins of commission.
Maybe I'm asking the same questions, Justice Stiegel and others, but how fair is that when you have one parent that is, they're in it together. One parent's going to try and lift themselves up out of a very bad situation, economically, otherwise, works 70 hours a week. But for those efforts, there may not have been housing, there may not have been transportation, there may not have been some of the signs of progress that arguably exist here in this case. And then, just because your second partner or the other person on your team drops the ball, it almost seems like all those efforts just fall to the wayside. And maybe that's your argument, is just that's just the way the law is. But how is that equitable? How is that fair?
Justice Wall, I think it's equitable and fair because the concern is the best interest of the children. Given 382201B1 mentions the health and welfare of the children has to be paramount. Although it is unfair to father that he's willing to be half of a plan that says, I'll work 70+ hours a week, I'll bring in the income we need to have a 5-bedroom house, it is still his obligation as a parent to ensure the best interests of the children, that other parent has a reasonable responsibility to care for them. Certainly, this court and others have upheld in the past that if there's a domestic violence situation, where a parent allows drugs into the household, that can be a problem for the other one. The district court even recognized, and Judge Schoening did, that clearly father does love his children based on the success of overnight visits, and that father did hold down a stable job for a number of years. But it's not enough if father's going to continue to promulgate a system and a marriage that allows the children to be watched by someone who fakes drug tests, who tests positive, and then say, well, she watches them, she's responsible for these things, I do this thing. Eventually, the obligation becomes upon the father when the best interests of the children are hurt.
I'm just saying, doesn't that obligation only arise after a legal finding? Because none of those presumptions apply prior to the finding of the court with respect to those factors of unfitness and best interests.
So in this narrow instance, Justice Stiegel, I don't think it does. And my reason would be, I think that past behavior shows how he parents, where the father allows the children to be in a situation where their primary caregiver would be someone who tests positive for meth, lies about results, and would not be a good influence on them. So I think it's reasonable to make an inference, even in this narrow lane, that says, hey, what would we think in the future for a father that let the primary caregiver be somebody in such a terrible situation?
So I have kind of a series of big picture questions. I have to beg my colleagues' indulgence and ask you to bear with me if I could just kind of run through this series of questions. And again, I want to hear the state's input on this. I really want to shift the focus for these questions from the unfitness finding to the best interests finding. And so I want to start with just trying to understand what is the right at stake. We often, perhaps always, refer to these as parental rights cases. But what we're talking about here is really the natural bond between a natural parent and their children. And I guess my first question is, do children also have a right to that bond? And the basis of that question comes from this court's decision in Frazier, in which we said that, and that wasn't a termination case, it was a co-parenting agreement case, but we did say that the constitutional rights of the children, as well as those of the parents, must inform the court's determination. Is that true here?
I think both things are at play, Justice Siegel. I guess an analogy might be free speech cases or freedom of religion cases, where you have both free exercise and the right to be protected from an establishment of religion, the sort of play in the joints that comes into play. So I think in this case, obviously parents do have a constitutional right to parent their children, but we know from the Constitution as well, children do have rights, which is codified in 38-2201B1, which said the health and safety of the children's paramount.
I'm asking about constitutional rights. Do you think that do you think children generally have a constitutional right to the natural bond that exists between themselves and their natural parents?
It is a interesting question. I'm certainly willing to indulge the question without briefing. I do not think there is a recognized liberty interest that says you have a right to that natural bond between parent and child, but I think there is a parental right that would attach.
So that right is often referred to as a fundamental right. Typically, we draw this language from federal case law that has recognized a fundamental right to parent, probably arising under the Due Process Clause. But this court, in other cases, has held, and I'm quoting again, that the core of the natural rights of liberty and the pursuit of happiness protected by Section 1 of our Bill of Rights includes something that we previously have called family formation. Do you think that this natural bond that we're talking about between natural parents and children is something protected as a natural right under Section 1 of our Constitution?
I think that is a narrow question. I'm happy to indulge it today without full briefing and looking at the history behind what that would have been legislatively and textually. My guess is a constitutional right for the child attached, if that's your...
I'm thinking of the parent now.
You're thinking of the parent, Justice Stiegel. I think the parent has a constitutional right to have children and to be involved in their children's lives. So I think there has to be a burden from the state to carry past it. But I don't think there's a unique constitutional right that says this is a separate one. You have a right to the natural bond here as opposed to something else.
So your answer is no, it's not protected by Section 1.
That would be my general thought, Justice Stiegel.
So moving to the best interest decision determination, and the statute just says after termination, or excuse me, after a finding of unfitness, there's a second step before termination, which is a finding of the best interests. And I guess my general question is just what standards guide the district court's determination of the child's best interests? Are there any objective standards?
I think the objective standard would be looking at what are the situations that are developed and what are the options and alternatives. I don't think there necessarily is.
That's not a standard. That's case specific. I'm asking if there are any in law, any objective standards.
I think the objective standard would just be health and welfare that's statutorily. I don't think there is an 8-factor test or anything objective like that.
I think you're right. I mean, I think the statute says, look at the children's mental, physical, and emotional health. Is that an objective standard?
I think there is a lot of subjectivity in that, Justice Stiegel.
It seems like there is to me as well. And in fact, our case law recognizes this. It talks about it as a highly discretionary decision, and we review it for an abuse of discretion. But I kind of want to tie these things together and just ask, do you think the constitutional dimensions of the right at issue needs to factor into the court's discretionary decision about the child's best interests?
I think, Justice Stiegel, it should be in play. And so we're obviously discussing several hypotheticals here, but for the purpose of your question, I think it should be considered if there is that right. But I would say I think it is considered by the court because that finding of unfitness has to be made at a higher, clear and convincing standard. And then I think given the rights of the child, once you've had a higher standard made for clear and convincing, just having preponderance makes sense because that's when the rights of the child come into play. So I do think that's a good workable solution with where those rights might come into play. But I agree, given how long it's been since the Kansas Supreme Court has had a child in need of care case, there is some untouched standards for some of these areas of law.
I appreciate that. And here's my last question. So I appreciate your indulgence of this list of questions, but this is really case specific, not hypothetical. As far as I can tell, the lower court in this case, when rendering its best interests finding, relied on only one factual component, and that was the length of time the children had been in foster care and the strength of the bonds the children had formed with their foster parents. Would you agree with me that, at least in the record, that's the only factor cited by the district court?
So Justice Deagle, I think that's a possible reading of it. My reading of it, though, given how long Judge Schoening goes through, I think those findings made under unfitness and foreseeable future can also be applied to best
Well,
interest.
you would agree with me that the district court did not explicitly do that.
They did not explicitly do that, Justice
But
Deagle.
when making a best interest finding, the district court explicitly referenced only those two things I mentioned, period of time and the bond formed.
I would agree with you, Justice
So
Deagle.
now my question is, courts across the country there's a trend, as I discern it at least, in courts across the country disfavoring those factors as factors that can be considered by district courts when rendering a best interest decision. And I've got Supreme Court decisions from Maryland, Massachusetts, Nebraska, a number of states have looked at this and said that that's not a proper factor to consider when rendering a best interest determination. Do you think Kansas ought to adopt that kind of a rule, with respect to Kansas determinations of best interests?
Which factors? You mentioned two.
The length of time and the bond. Both, right? I'll just read one for an example out of Massachusetts. The bonding of children with their foster parents cannot be the dispositive factor because the very fact of placing a child in foster care during judicial proceedings would in every case determine the outcome of the proceedings. That's a quote from Massachusetts, but there's many more. And I just wanted to get the state's perspective on the appropriateness of using that. I mean, in other words, is that an error of law for the district court to rely on those factors?
So Justice Deagle, and I see I'm out of time. Justice Rose, may I continue? Thank you. I don't think it's an error of law, and I would disagree with Massachusetts' perspective there. I think best interest of the child necessitates looking at what the options are, much as the state's asking to look at what are the interests between mother and father and saying they're in this case bound together, although in other times they may not be.
You don't agree that again, the natural parents are put at an extreme disadvantage by the fact that their children are taken from them. They will develop bonds, presumably with good foster parents. And then all of a sudden, when it comes to best interests, that factor is now used against them to terminate their rights.
I think it does disadvantage the parents, Justice Deagle, but I think it's a justified disadvantagement and a hopeful disadvantagement because the parents, by having that finding of unfitness, would necessarily be in a problematic situation. So you would hope the new one would be in a better spot. So I do hope the court considers that. And if it ever happens where, hey, it shows that the adopted parents aren't doing a very good job of adjusting to the child, or it shows once adopted, hey, these medical issues we thought were the fault of the parents haven't been resolved, then that would provide strength for the parents. So I think those comparisons matter. And since best interest of the child is so paramount in our legislative standards, I think the court should continue down that road, and at least for now in this case, until a full briefing has been done.
Well, is it fair, may I ask a question? Is it fair for a father to be assessed a negative inference of any kind because for a period of time, he's allowing someone else take care of his child? Should he be dinged for that at all? Because he may say, well, I don't have to tell you what I'm going to do. I'll just take care of them. but he hasn't been. Somebody else has been performing that responsibility for 40 months. So what effect does that have on the parent who is not doing it?
So Justice Wilson, I think the parent can be dinged in that situation because the parent has an obligation to look into the circumstances. I would think a district court, when evaluating these factors, should give some deference at the beginning. If a father says, look, I worked a lot, this is the first I've heard about positive drug tests or problems, but I think at least it becomes case specific. And in this case, where there are fake documents, where mother is on probation for possession of meth, for identity theft, for criminal threat, and when she's saying, well, I have these diet pills, that's why I'm testing positive for meth, there does become that obligation on the father. So I would agree with you. There should be deference given to one of the parents at the beginning when they hear one of the other parents is screwing up. But 40 months is when deference disappears and reality sets in that this was not a suitable situation for the children.
Colleagues, any other questions? Thank you, Mr. Cott. Would you like to finish up and summarize?
Thank you, Justice Rosen. We are simply asking this court to affirm the decision of both the Court of Appeals and the District Court terminating father's parental rights. Thank you.
Thank you. Mr. Klein, you reserved 5 minutes.
Thank you. I just have 2 points I'd like to make. The first is when you have a case like this, you're in essence telling the father to make a decision in the middle of the case before he knows the outcome of the case. And you're basically saying, look, if you want your children, you need to separate from your wife. And I don't see how in child in need of care cases that you can do that. It's unfair, and it seems like as a social construct, telling parents to separate unless there are just egregious facts. And we see those cases. We know there's physical abuse, sexual abuse. There are terrible cases. This isn't one of them. Doesn't look like one of those cases. And
Why
in a
doesn't
case
it look like
this-
one of those cases?
I'm sorry?
Why doesn't it look like one of those cases? Knowing that she would be the primary caretaker of those 4 children.
I think that's an assumption that's not, I don't think that's supported by the evidence.
The evidence is he works
Yes,
a lot.
yes. But there are other things he could do to make sure the children are taken care of.
That ever raised.
No, and again, I think you're trying to shift the burden to because they weren't, you don't figure those things out until parents in these cases don't figure those things out until reintegration is imminent. And there are all kinds of things he could do. He could put the children in childcare. He could hire a nanny. There are tons of things he could do to take care of the children.
Okay, so
Without mom.
there was the
taking care.
ICPC, okay? And so you had Missouri DCF or whatever they're called, go in, and at that point, isn't it at that point that they're looking at the house and they're saying, they're asking the questions, right?
They
What
are,
are you gonna do for
yes,
childcare? What are you gonna do for this? Right?
yes.
And they didn't approve it.
They did not approve the ICPC because another child was born in Missouri and they started a child in need of care case, their version of a child in need of care.
And then
case
another ICPC
for-
was signed
for that child.
by Jed Schoenig.
That was the second one was they had a child in need of care case. The first one was they didn't get back to the social worker in time to sign paperwork. The second one was they had again, Missouri's version of the child in need of care case. I don't know what it's called.
Right.
And
why
that's why
wasn't
they
this
didn't
all-
approve it.
Yeah, I mean, wasn't this discussed? I don't understand,
I think it would have been discussed and they would have had a plan, but you're right, the plan is not in the record.
I think, when, maybe I just, you're much more familiar with the record. But I don't know what the parenting plan said. Usually, not the parenting plan, but, well, I guess it is a parenting plan, but the things that you do, doesn't it say somewhere in there who's going to take care of the kid, what the plan is?
And I don't think you would have that locked in and figured out until reintegration was imminent, was going to happen. You're at weekend visits over a series of months, and then you would have this figured out, this is what we're gonna do during the week to make sure that we continue to go forward.
Okay, and so why weren't weekend visits given? Why didn't we ever go from supervised to unsupervised except for the one instance?
Well, they were doing tons of unsupervised visits. They did unsupervised visits all the way until DIG was born. And then they were doing half-day visits to that point, and then then visits went back to supervised for a period, then they went to unsupervised. They got to the point to where they'd done one overnight, and that was about the same time the child in Missouri was born. Missouri started a case, and that social worker found out mom was forging documents.
Okay, and so we don't do any more unsupervised visits.
And after that, there were no more unsupervised visits after that.
And that had nothing to do with dad.
I would argue that had nothing to do with that. I'm super short on topic. Can I make one more?
Yes, oh,
quick point?
please.
I'm sorry.
I'm sorry,
Um,
please. Please.
Can I go over by about 30 seconds, Your Honor? Thank you. I wanted to make sure we're clear on, there are at least three things we don't have defined in the Child Native Care Code. The first one Justice Stegall brought up, and that was, what is the best interest standard? That's the first one. But there are two other big ones we don't understand either that apply to this case. The first one, definitely. We don't know what a fit parent looks like. The code tells us over and over again what an unfit parent looks like, but there are probably only two cases that were reversed from district courts based on the facts. That's In Re AA and In Re AM. And those cases kind of tell you what a fit parent looks like, but not exactly, because these things get so case specific. So we know what an unfit parent looks like over and over and over again based on the case law. The third one we don't understand exactly is what are reasonable efforts. And because the district court here found that, reasonable efforts were used to reintegrate the family, and I'm not sure that that was a correct finding either, based on particularly KVC's lack of work in the case, and they got to Missouri, and a Missouri caseworker found out there are tons of problems that hadn't been identified earlier that could have been worked on potentially. But there are, beyond the best interest standard, it's a number of other things we don't exactly know what it looks like. And that's that's the final point I'll make.
Okay, so, do you know any state in the union that defines best interest?
I think, again, we know what it's not.
Because it defies definition, correct?
Potentially.
I mean, no state defines best interest, correct?
I believe so. I would have, it'd take a ton of research for me to really know the answer to that, but I would assume we only know what it's not, and that, unfortunately.
Does any state in the union define what an unfit parent is besides giving factors?
No.
Okay, and then, does any state in the union define with factors or whatever, what reasonable efforts are? Because all three of those defy definition, correct?
No, I think you,
Okay, so
I
define,
think they could be definable.
okay, give me a definition of best interest
I think you could,
besides the definition that's in the statute, which is physical, mental, and emotional needs of the child.
I think, like many other things, that this court could lay out factors to help a district court
What are they?
come to a conclusion on best interests.
Give me some examples.
I think a court should highly consider the bond between a parent and child. And I would argue that it's more important to love a child than to feed a child. That regard. I think that a court could use the amount of time a child has been out of parental care. I think a court could use the contact a parent has had with a child or children during the course of a child in need of care case. And I think the court could use a factor that determines how dedicated a parent was during the course of a child in need of care case.
So, it's your position that the factors, which are very long in 2269, that go to fitness, don't address any of those?
No, they don't. And but I think it's two separate things.
Okay.
There are.
Okay, so let me ask you one other thing. Do you have any idea whether any of the things that you've just mentioned have ever been considered in Kansas by a district court judge or in a reported case by the Court of Appeals or an unpublished case, or this court in deciding best interest? Are we precluded from considering those when we consider the physical, mental, and emotional needs?
No, I don't think a court's precluded, obviously. But I think it leaves a wide, leaves a very wide left and right limit to what a court should use or could use in determining best interests are. And I think that the more we narrow it down, the more helpful it is for district court to decide these cases based on the children in front of them.
So do you think that this is something that we as the court should do in defining physical, mental, and emotional needs the way the legislature wrote that? Or do you think this is something that the legislature should do, given they've already defined all the factors? Is this a legislative fix, or is this something we should do?
I mean, okay, so legislators laid out factors for unfitness. There's a big difference between unfitness and what's best for kids. Long run. And I think that I think there's a presumption by district courts that once there's a finding of unfitness, that it's probably the best thing to do is terminate parental rights. And I disagree significantly with that view.
Right, and I think that is probably a more accurate target of what the issue is, rather than trying to define what best interest is really, this is what the legislature did. It has a whole separate section here. This is best interest. This is not based on the factors. And I see your point there.
And I'll just have a quick follow-up. Justice Standridge's questions caused me to think of one more question. And that is, if best interests is really undefinable, as Justice Standridge indicated, at least suggested possibly in her question, does that really mean that a district court has what amounts to unfettered discretion to make that ruling in our existing law?
Well, because it's looked at under an abuse of discretion standard, I don't want to, yes, it's unfettered.
I mean, it would be,
yes.
if you're operating on an undefinable term, it seems to me, if there truly are no objective standards, it's unfettered discretion. My
Yes.
question is giving a district court unfettered discretion to enter a ruling affecting constitutional rights consistent with a system of rule of law that supposedly guards citizens against arbitrary rulings?
No, I don't think so. I mean, the abuse of discretion standard in determining best interests, to me, is absurd.
Well, I'm going to push back a little bit, if I may. Best interest or abuse of discretion has three parts. Whether or not the judge's decision is based on an error of law, an error of fact, or no reasonable judge would do this. So you're still fettered, even if you don't have a mistake of law or fact, you're still fettered by, you have to be reasonable, right?
Yes. But I mean, I think we all know, how many cases are reversed on abuse of discretion? Not very many.
Well, when when you think about search and seizure, something reasonable. Yeah, we reverse on those. And that implicates a
But-
constitutional right.
But in those cases, there's a huge line of factors and
Factors, those aren't factors, those are case by case.
sure, but
Looking at the
if-
facts, all of these cases are very fact intensive, just like in a case of a car stop.
I'll agree with that.
Any other questions, colleagues? Thank you. You want to finish up, summarize?
I'll just say again, this kind of case in particular with two parents, one who I'd argue is not fit and one who I would argue is very fit are just tough. And I think you put a parent between a rock and a hard place when you say, pick your kids or pick your wife. And it just seems to be an unfair proposition as a start point for a parent.
Thank you. And I want to thank you, Mr. Klein, Mr. Kaut, for your arguments this morning. The court will take this appeal under advisement, and by that I mean the court will now conference the case, probably today, in which a justice will be assigned to draft the opinion, and it might be in the circulation of that draft opinion. There could be differences of opinion, which could result in a concurring opinion or a dissent. And all of that will be finalized and circulated amongst us. And once that process is completed, the case will be published in the Kansas Court record, and a news release will be issued. So thank you very much. You're excused. I will now call the case 125241, State of Kansas versus Francisco Alejandro Mendez. Counsel, please come forward.
May it please the court, once again, I'm James Latta of the Appellate Defender's Office, and I'm representing Mr. Mendez. As this court knows, this is a case with many convictions. We have a murder conviction, multiple attempted murder convictions, and multiple aggravated robbery convictions. My plan today is to focus on the sufficiency issues, specifically the insufficiency of premeditation and insufficiency of some of the aggravated robbery convictions. If this court wishes to talk about any other issues, I please ask this court to direct me to do so, because I want to talk about what your honors want to talk about. So beginning with premeditation, as this court, and I'm well aware this court does not like to find insufficiency of the evidence for premeditation. So in this case, my best argument, look, as a brief reminder, we're talking about incident, as I briefed it in my brief, incident number 3, where there was a Washburn party, and there was some football players from the Washburn University football team standing out in the front yard discussing what to do after the party. And according to the football players, a car drove up, asked them some questions, asked them if they had any marijuana. They said no. Another person in the vehicle asked them for their name. So one of the football players responded, "Don't worry about it." And according to the state's theory of the case, it was that answer, that disrespect, that then led to a shooting, as the prosecutor himself said in closing arguments, a couple seconds later. So my best argument to distinguish this case from the many other cases where this court declined to find insufficient evidence for premeditation was the state's own theory of the case was that this was an impulsive killing. So there was no premeditation based on the impulsive killing. The state itself started closing argument by saying, do you guys have any weed? What's your name? Based on those two questions, the prosecutor said, and in the time it took me to ask those questions, and the time it took this defendant to ask that question, do you have any weed? The decision to take a life was made. And then later on in that same closing argument, the prosecutor said that was a couple seconds. So our argument is that based on the state's theory of the case, they themselves conceded that there was insufficient evidence of premeditation, because the only way you can have a second-degree murder, as I've argued with this court before, is an impulsive killing. And in this case,
Didn't the shooting last a number of minutes with as many as 3 different guns, and there were 18 shell casings found?
I don't believe it lasted a couple of minutes. I believe it all happened very quickly within seconds. But I will concede that the shooting lasted more than a couple seconds.
And there were people, at least one person who was shot in the back after starting to run away.
That is correct. So my best argument that I have to say that these facts, when we review the sufficiency of the evidence, as this court has said many times, we view the evidence in the light most favorable to the state. And I will point out, I looked at it yesterday, and I can't find one case this court has said that in thousands of cases based on my research. This court has never said that we view the facts in the light most favorable to uphold a conviction, even though there's been numerous opportunities to do so. So my argument is that when we view the facts in the light most favorable to the state, we view the facts in the favor of the state's theory of the case. Because to do otherwise would be to not view the case in the light most favorable to the state.
That mean we have to ignore the actual evidence, the testimony that it was what, 10 or 15 seconds between shots or when the shot occurred? My point being that we have evidence from a witness, right or wrong, but evidence that's there that says 10 or 15 seconds. And then you're saying the state comes in at closing and says a couple of seconds, that we have to ignore the evidence and hold the state to whatever a couple of seconds means? That doesn't make sense to me.
That is my best argument I have to get around the standard of review that's very unfavorable to me.
Jury certainly wouldn't have been instructed consistent with that theory, would they?
No, but the prosecutor in his closing arguments, in my opinion, lowered the burden for premeditation by noting that it could occur within 1 second in one place. And then even when he started his argument talking about in just that time it took to ask those questions, was a very, very small amount of time. And so if the state had alternative theories of the case, I think the facts could support him. But my argument is that when the state comes in, they say, this is our theory. I mean, to me, it doesn't make sense to say the jury convicted on a theory not put before them.
All I meant is that the jury wouldn't have been instructed to consider only evidence that supported the state's theory. They can consider evidence admitted and that they were the finder of fact.
I agree, Your Honor. My argument is this, the best argument I have is that when the state puts forth its theory of the case and they convict, I think it's reasonable to assume that they convicted under that theory. There's no questions on premeditation. I'll move along to the aggravated robbery convictions. And in this case specifically, I'm asking this court to overturn 4 of the aggravated robbery convictions. As this court remembers, there was 2 different incidents of alleged aggravated robbery. The first one occurred when the vehicle was stolen and there were 2 alleged victims in the vehicle. And then a few nights later, there was another incident where there was a group of alleged victims in a vehicle, and supposedly Mr. Mendez came up and was part of a group that robbed them. And so my argument is that for the people that had nothing taken from them, there is no aggravated robbery. There is at most an attempted aggravated robbery. And specifically, I'll focus on the first incident, which is when the car was supposedly taken. The passenger in the car, his name was Will Clark. And the state's argument is that they had to get him out of the car to be able to steal the car. And I'll agree that that is true. But what makes this difference is this court's case law says that the gravamen of robbery is the taking of property. And Mr. Clark, he had no possession or control over the car. So even if the robbery hadn't occurred, he was not in a position to be able to control the car or say who could come in the car or had any possession over it. So in that case, there's no robbery because nothing was taken.
He was the
What-
first to leave the car, as I recall, correct? Did he leave the car before the driver relinquished the car?
I believe that is correct because I believe the driver stayed in the car refusing to get out for a little while.
Is there an ownership requirement or a property interest requirement in the aggravated robbery statute?
No, I don't believe so.
So why isn't the taking of the car from the presence of Clark sufficient?
Because this court has said that presence doesn't literally mean present why something is taken. This court has said that it means you have some possession or control. He was not in possession or control of the car. Just because you have to, someone is making it difficult for you to take something that isn't theirs or they have no possession of, that's not a robbery because robbery we're focused on the taking of property. So if nothing's taken from his possession or control, there's no robbery. There might be some other crimes to remove him, but there's no
So
robbery.
your argument hinges on the lack of control of the car?
Yes.
But as I read our case law, it's it has to be a presence that's of the nature that it required force or threat of force to remove that individual from the property. But for, an armed robbery, this passenger would not have been depossessed of that vehicle? Or how would you respond to that argument?
I mean, I would say he was never in possession to begin with. So how can possession or control be taken from you when you don't have it to begin with? I mean, he wasn't driving the car. I mean, you can get possession and control lots of ways. If someone said, drive my car somewhere, then I'll concede that they're in possession and control of the car, even though it's not theirs. And if someone else was driving it, they wouldn't be. But that just isn't the case here. I mean, there's lots of other crimes for forcing him, battery, threat, but it's just not robbery. Think of the hypotheticals we could come up with.
Well, we have lots of, I think, Fourth Amendment cases in which courts have found that items inside of a car are in the control of passengers.
Sure, I would say that Fourth Amendment doesn't apply here.
Well, I know, but conceptually, the question of whether or not a passenger controls property of the car or the contents of the glove box or what have you has been litigated before. Courts have found that passengers do exercise some control over that property.
Sure, my response would be if that's the case, and that's certainly not what happens here. I mean, he can't direct where the car goes. He could ask the driver, but she has her own free will what to do. Without the robbery, my basic argument is if you're not in possession and control before a robbery begins, we can't say afterwards you were in possession and control. I mean, like I was getting ready to say, the hypotheticals we could come up with, I mean, if you rob one person in a football stadium, I mean, you have 50,000 robberies.
And just to clarify, you're arguing against 4 of the ag robbery convictions.
Yes,
We've just talked about Clark.
right, and
And the other 3 are Cool, Hodge, and Farah Fontov.
that is correct. And those were from the last incident. And in that case, there was nothing taken from them either, in all those. And the state concedes that Cool was.
Thank you.
And so I guess since you brought that up, I think we know that when they say got their pockets run, kind of a slang phrase, I cited a case where they've talked about that just means they're looking to see what you have. And even if this court doesn't want to rely on other cases, the state never got any evidence of what that phrase really means. So either way, that has to go against the state that nothing was taken from those.
So
three.
the state conceded as to Cool,
That is correct.
right? But as to the other 2 on that Central Park incident, there was testimony from Strika, I don't know if I'm pronouncing that correctly. And it was, that testimony was, but as far as I know, Hodge, he got his pockets ran, so did Farah. Cool's the only one they didn't get nothing out of. So those two sentences together, could a jury reasonably infer that running of the pockets combined with Cool being the only one that didn't get something taken from them support the convictions for those two victims?
I don't think so because, would you mind reading that again? I'm sorry, Your Honor, I don't usually do that.
Yeah. This is from Strika, but as far as I knew, Hodge, he got his pockets ran. So did Farifatoff. Cool's the only one that they didn't get nothing out of.
Sure, and my argument would be reading that all together in context. We don't know for sure that they got any, I mean, even viewing it in the light most favorable to the state, we don't know for sure they got anything taken from them. They said they got their pockets ran. I mean, my argument would be that that's not conclusive enough to find beyond a reasonable doubt that they had something. And I believe there was other testimony later that their pockets were looked into, but there was never any conclusive testimony that something was taken.
I guess it's, yeah, the pockets ran, but it's coupled with the testimony that this other third party, Cool, was the only one they didn't get anything out of.
My response would be reading it in context, it would still uncertain, because they only said they got their pockets ran is my response. There's no other questions, Your Honors. I just ask that this court reverse and remand consistent with my brief, please.
Thank you, Mr. Ladd.
Thank you.
Lifton.
Thank you, Your Honor. Good morning. May it please the court. The state appears by Deputy District Attorney Jody Litfin. I'm going to stick with the sufficiency issues as well, unless this court has any questions. As far as the first issue, our position is that the state presented sufficient evidence here to convict the defendant of premeditated first-degree murder and the 4 counts of premeditated attempted murder. And again, we've talked about the standard, viewing the evidence in the light most favorable to the state, not the prosecutor's comments. So we have to stick to the evidence here. Even the gravest offenses can be based on circumstantial evidence. And there are 5 factors that this court has commonly used to go through finding inferences of premeditation. And the first being the nature of the weapon used. And here there were guns used. A gun is unquestionably a deadly weapon. The shooting involved 3 different guns, 18 shell casings, the revolver bullet that was eventually found in the victim's head. There was a large number of shots here, so that infers premeditation. There's case law saying this. And the witnesses described the shooting as being slow at first and then more rapid. And then everyone ran. And then, as Your Honor was saying about the other victim who got shot in the backside, indicating that he was running away and they were still shooting. The bullet that came from Simmons came from a revolver. I'm sorry, the bullet that killed Simmons came from a revolver. And we had evidence that that was the same revolver that the defendant claimed was his in that April 14th car stop. So we believe that the nature of the weapon used in this case can be used to infer premeditation. The second factor is a lack of provocation, and the evidence showed that the group of men, the football players, were all outside talking about what they were going to do the next day. They were actually getting ready to leave the party when this white Chevy Cruze pulled up to them, and someone in the Cruze asked if they had any weed. The group responded no. Someone else asked their names, and the group either said nothing or don't worry about all that. And then the Chevy Cruze drove away, but then stopped, and then the shooting began. And our position is not telling a car full of strangers your names after they ask you for some weed and then ask you your names is not provocation at 1 o'clock in the morning. Is not provocation to be shot with 3 guns 18 or 19 times. So we believe lack of provocation in this case can also be used to infer premeditation. And the third factor that the state put forward is the defendant's conduct before and after the killing. After the football players told the men in the car that not to worry about their names, the car began driving away, and it did drive away and then stopped moments later. And then the shooting began. We also have evidence from one witness who said that he actually saw people outside of the car shooting into the crowd. So the fact that the car initially drove away and then stopped in order to shoot the group of football players 18 times and then fled the scene following the shooting, we believe infers premeditation. There's also a jail phone call that the state presented where the defendant was talking to his brother about the gun and the search of the house. And they were discussing, hey, did they find your thing? They didn't find my thing. And he said something defective. No, they're not going to find it. It's not there. So we believe that phone call also talks about him not having the gun any longer that was used in the shooting and can infer premeditation. So we believe that the totality of the evidence in this case, viewed in the light most favorable to the state, does establish premeditation. And then for the aggravated robberies, I think this court's hit on the issues that essentially is the state's argument. We would argue that Clark, the passenger in the carjacking incident, did have possession or control of the vehicle enough to have the sufficient evidence of person or presence in the aggravated robbery statute. I don't know that I don't believe there's a case that says that dealing with a carjacking issue. But I think based on our, this court's case law about what presence means, we can argue, and there was sufficient evidence that the car was taken from his presence. They returned to the house. I'll just go over the facts quickly. He returned to the house and they were surrounded by the defendant on one side, I think, and maybe two other men on the other side. So they come quickly out to surround the car. One said, "Where's the money at?" The defendant, or one of them, was at least armed with a revolver and told the driver to get out of the car. Clark was forced out of the car, but knocked over one of the men and rushed inside. So, but for them coming out and saying, "Where's the money at?" coming to them armed with guns, he would not have gotten out of the car to go inside to get his gun, is what he said. So we would argue that this evidence was sufficient to show that the car was so within Clark's control that he would have retained possession of it, if not being overcome by the threat of bodily harm or force. And then to the Central Park robberies, I think this court has already gone through the evidence that we have. I think you finished the part of the quote that I might have had in my brief, talking about Ms. Cool not having anything taken from her. But the testimony that the state cited for those aggravated robberies as to Hodge and Farafontoff were, as far as I knew, Hodge got his pockets ran, so did Farafontoff. And then another witness saw the defendant and men demanding money from others and picking pockets on other people to see what they had. So we would argue that this evidence establishes that those two, Hodge and Farafontoff, had property taken from their person.
If there's, I was gonna say, if there's no testimony that from that witness that Cool's the only one that they didn't get nothing out of, if that isn't testimony in the record, I don't see how it just got their pockets run, how that proves that there was a theft of, or a taking.
And yeah, in response to that case that said that was just going through their pockets, I guess the state would say it's a reasonable inference to say he got his pockets ran would to be removing items from the pockets. And I guess that's my best argument as to, we would still say that's sufficient and got his pockets ran. I think there's a reasonable inference that they can say they took things from the pockets. And if there's no other questions, I guess I'll just submit.
Well, I'll turn to the prosecutorial error
Okay.
portion. Can a prosecutor really say that premeditation can happen in 1 second? Is that a correct statement of the law?
I don't think our case law says. I think there have been cases from this court that say the prosecutor cannot say that it can be formed in half a second or a second. I think Kettler, I can't remember.
Cannot say that.
Right. I think this court has said that that's a misstatement of law to say that it can happen in a half a second or a
And is
second.
that what the prosecutor said here?
Did,
So you concede error
we did,
on at least that one.
we did.
Okay,
Mhm.
that's what I wanted to clear.
Don't like to do it, but we did here. But he also said it can happen in 5 seconds, and that's where our disagreement is. We don't believe that he said, and I could get to it in context. After he's talking about the instruction on premeditation. And that's all it takes to form premeditation if the evidence supports it. And he had just given an analogy about picking up an envelope, which we think is a proper analogy to talk about premeditation. To have thought the matter over beforehand and then acted on it, that's what premeditation is, which is the definition that the jury got. It can be a second, it could be 5 seconds, it could be 2 weeks of premeditation. The evidence has to support that the defendant thought the matter over beforehand and then acted on it, just as that instruction tells you.
Yeah, so your concession is only to the 1 second comment, but
Yes.
in context, your argument is harmless because in toto, the proper standard was articulated to the jury.
Yes. And we presume that the jury followed the instructions, they got the proper premeditation instruction and giving, secondarily, as Sherman said, the, substantial evidence in this case of premeditation.
Colleagues, any other questions? Thank you, Ms. Lifkin.
Thank you, Your Honor. We would just ask that the court affirm the convictions in this case.
You reserve 3 minutes, Mr. Latta.
Thank you, Your Honor. I have one point to make and then we'll see if that leads anywhere. Talking about the Fourth Amendment and possession and control, I'll point this court to your case in State v. Schuerman. I think is how you say it. I cited in my reply brief. In that case, this court held that even though there was a passenger, that they had neither a right of lawful possession or control of the vehicle, even though they were a passenger of the car. Other than that, I have nothing else to say. If this court will please reverse and remand consistent with my brief.
Any other questions?
Thank
Thank
you.
you, Mr. Latta.
Thank you, Your Honor.
And Ms. Lifkin for your arguments this morning. This court will take this matter under advisement and court will be in recess. I'm going to get this right this time for 15 minutes, but I'm going to add to until 10:45. Thank you.